Hi, this is Kurt Harris with the Men's Family Court column. Today I want to talk to you a little bit about community property and how it applies and give you a little historical background on community property. Most of the western states are community property states, Utah excluded, where I'm licensed to practice. But community property is prevalent throughout the other western states. Community property came about out of California back in the late 1800s when miners were coming to California and leaving their spouses back east while they came out to California during the gold rush. Many miners struck it rich and abandoned their wives in the eastern states. California passed a law thereafter that community property law is what came about. The community property law indicated that if the miner struck it rich, that his wife that he left back in the eastern states would now be the owner of half of his estate, or half of the gold strike. That provided the impetus and the motivation for those miners to go back and get their wives that they had abandoned back east, or to bring them with them when they came out west chasing the gold. That's the inception of community property. And so the point behind community property is that half of every dollar that any individual earns during the course of marriage is 50-50. Either party or both parties are a 50% owner in that dollar. Every single dollar that is earned. So it is something to think about when you approach what your assets are and when they were purchased. Many of us have assets prior to marriage, and it requires a different calculation or assumption, and many of us have assets that are acquired during marriage. All assets acquired during marriage are considered to be community property unless they're acquired with separate funds, which we'll go into at a later date. But bear in mind at this point that all of your assets that are acquired during marriage are community property unless you can prove otherwise. And that means that your spouse has a right to 1/2 of all of the assets. So that car that you purchased is 1/2 your spouse's. That house that you purchased during marriage is 1/2 your spouse's. It does not matter from whose earnings the mortgage payment was paid. It does not matter from whose earnings that car payment was paid. The car is 1/2 each. The home is 1/2 each. The origin of it is derived from community property funds. When you go to work that day, 50 cents on every dollar that you earn belongs to your spouse if it is earned during the marriage. That is how it is looked at. That is how it is calculated. Now, when we come down to the property, you can't divide these things 50-50. If you have a single couch, the right half is not yours and the left half hers. All of the couch, 100%, 50% undivided interest is hers. You can't divide the interest of the couch. She can sit wherever she wants on that couch, and you can sit wherever you want on the couch. It can't be divided equally. It is just owned jointly 50-50. That's how the analysis goes. Sometimes that can be very difficult for many of my clients who have bought the house in their mind. Her name may be on it, it may not be on it, but they've paid for it out of their salary during the course of marriage, and at that point it's a very bitter pill for them to swallow that she's entitled to 1/2 of the equity of the home. She is. She may have been at home, she may have been taking care of your children, she may have been doing other pursuits in the marriage, but those are incalculable. So at that point she's entitled to 1/2 of the equity of the home. That's the way that community property is calculated. In the future, we'll dive in a little deeper to some of the nuances of community property law, but as a basic overview, 50-50 on any item earned during the marriage. Anything earned during the marriage is classified as community property in the community property states. This is Kurt Harris with the Men's Family Court column. I look forward to speaking to you on other topics in the near future. Thank you.